This is HuffPost Live. I'm Mike Sachs. George Zimmerman, the former neighborhood watch leader charged with fatally shooting Trayvon Martin last year, told a judge today that he agrees with his defense attorney's decision not to seek an immunity hearing under Florida's Stand Your Ground defense law. Joining us to discuss this is trial attorney Richard Roth. So Richard, first, can you explain to us what an immunity hearing under Florida's Stand Your Ground defense law is in the first place?
Sure. Hi, Mark. What happens is in Florida, unlike many other states, you can actually have a hearing on what they call a stand your ground law. It's actually a separate hearing before the judge, and if you can show as a defense that the person being charged actually stood his ground and has reason to believe that he was suffering imminent harm, that is, a gun was being pointed at him, a knife was being wielded on him, then he can win the case, and the case can be dismissed before it even goes to a jury. So it's a very strong, it's a high standard, but it's a strong way to get rid of a case criminally.
So then why did he decline this? Why did he decline this hearing and instead choose to go to the jury with this?
Yeah, there's 3 or 4 different reasons it may have happened. We don't know exactly what went on behind closed doors in the attorney-client relationship, but one reason is he may have thought he was going to lose that, which would be bad press, quite frankly, and you know, jurors will be following the press on this. So it could be very well that he believed that he didn't have a reasonable ground to pull out a gun when Trayvon had, as it's been reported, nothing on him, so he could lose it. The second reason could be that he doesn't want to waive the the Fifth Amendment privilege. Remember, the only person who could testify in that hearing would be the defendant. So he would have to waive that Fifth Amendment privilege in order to testify, which may be something he didn't want to do. And the third reason could be, I guess it could also be money, but the fourth reason would be that he wants to just roll his dice with the jury. Doesn't believe the prosecutor will be able to prove its case, and at which time he will make a motion to either have the hearing at that point then with the judge, or just put on his defense after the prosecutor is arrested.
So he has more faith in a jury of his peers than he does in the judge on the bench in front of him, which I would think, with this case being as big as it has been, that the jury might, in fact, because frankly it'd probably be hard to find a jury that isn't totally aware of what's been going on, that the jury would be more inclined to try him in the court of public opinion, or has already tried him in the court of public opinion, whereas a judge, you'd think, would be more impartial. So it's a weird roll of the dice that I think he made.
It's definitely a roll of the dice, but remember, the chance that you're going to get any emotion is going to only be with the jury. A judge is not going to. Judges put people in jail every day. So what the judge is going to do, the judge is going to say to herself, in this instance, to a woman, did the defendant, did he have a reasonable basis upon which to assert the stand your ground defense? So in other words, did he believe that Trayvon Martin had a gun or a knife? And if he can't prove that, then he's going to lose that argument. And it's another sort of, if you will, scar against him when it comes to a jury trial. So my belief, my best guess is that counsel made the decision that they're going to lose that hearing, in which case they might as well roll the dice before a jury.
Now, Zimmerman's defense attorney, Mark O'Mara, also asked the court to unseal details on the civil settlement Martin's parents received from Zimmerman's Homeowners Association. So how do those documents help Zimmerman's case in this case?
Yeah, we don't really know what has been disclosed in discovery. I know that Mark O'Mara has made a motion to actually for fees against the prosecutor because he believes that a lot of stuff hasn't been produced. What will happen essentially is, assuming they do allow television in the courtroom, which would be nice, we will have a dissecting of that trial. Right now, it's a lot of guessing going on because the only people that really know what's going on are the prosecutors and the lawyers for the defendant here. So Mark O'Mara. So I wouldn't want to guess. I believe that it's a tough defense to show that he could stand his ground if really there was nothing being aimed at him vis-a-vis a gun, a knife, even a hammer.
Now, they're still in pretrial motions, pretrial hearings and such. There's going to be jury selection. There's going to be a trial. Do we know how long we can expect this trial to be?
Yeah, we don't know, but it's not that difficult of a case. We have unfortunately, a deceased victim. We have how many witnesses were there? How many people were actually there that saw the defendant or the victim that day? So this should be wrapped up. It takes a while to actually select a jury and instruct the jury, and there's going to be pretrial and trial motions. This should be wrapped up in, I'd say, a couple to a few weeks at most. We don't know yet, but I would probably reserve 3 weeks total.
Richard, we're going to get some very different legal analysis from you right now. We have TMZ reporting that Los Angeles Lakers player Steve Nash allegedly does not want to pay his estranged wife, Alejandra Amaria, child support for 2 reasons. 1, he thinks she is already getting enough money, and 2, he thinks if she gets too much, she might spoil their 3 kids rotten. So, Richard, how did the Arizona courts rule on this one? Do we know?
You know, you just can't make this stuff up. It is actually somewhat humorous. But the Arizona court actually ruled in his favor. The court said that they believe that Nash's payment should not go up. So there must have been some semblance to the truth in his defense. It will be appealed. But it's ironic because as much as he says he wants to live with the kids, he apparently objected when she wanted to move from Phoenix back to Los Angeles, where he currently is. So, you know, it's just, on the one hand, it's comical. On the other hand, we are dealing with children. We are dealing with real money here.
I mean, if I'm remembering family law correctly, any family law is just based on what's in the best interests of the children, right? So maybe the judge felt it is in the best interest of the children not to be spoiled rotten.
Absolutely, and it's BIC, best interest of the child. You're absolutely right, and what it may very well be that he's paying her a lot of money, and that the kids have, you don't know, they could have a car service picking them up from school, they could have tutors, they could have all kinds of stuff, they could have extracurricular activities which most kids don't have, and you know, it takes a lot of guts for a judge to say, you know what, these kids should be well grounded, they don't need more money, and my hat's off to that court.
Well, I want to thank you very much for joining us, Richard. It's been a pleasure talking with you. And,
thank you very much.
Of course. And coming up, we talk to Angie's List founder, Angie Hicks.